Welcome back. This is Philip Bickel at Legal Tyranny. It's July 8th, 2021. We're working our way through this opening brief for my traffic infraction case that was started in 2016. And right now we're in the middle of the argument section, so let's go ahead and continue moving forward. There's state prosecutors who are set with the task of prosecuting criminal or civil actions in the name of the state, not civil or not enforcement officers who are not licensed to practice law and therefore cannot legally or cannot represent the legal entity of the state in a court. Sorry, I'm trying to check the time while simultaneously reading. All right, might have to break this up. Okay, so these are all codes you should look at. I've cited them in my other videos. In this video, I'm actually putting them in here for you, so you don't have to do the digging. Although you should. If you want to get good at this, do the digging. You'll get really quick. You'll be able to go to any state you want to and find exactly what sections you need. Attorneys, license required. Except as provided by the rules of court, no person shall be allowed to practice in any court of the state unless that person has been duly licensed to do so by the Supreme Court, provided that nothing in this chapter shall prevent any person, plaintiff, defendant, or accused from appearing in person before any court and there prosecuting or defending that person's, plaintiff's, defendant's, or accused own cause without the aid of legal counsel, provided further that the district courts in sections 605.13 and 633-28 shall apply. Okay, so this point was made in numerous filings by me, which probably also included my motion to dismiss for lack of all jurisdiction. This one also. Unauthorized practice of law prohibited. It shall be unlawful for any it shall be unlawful for any person, firm, association, or corporation to engage in, or attempt to engage in, or to offer to engage in the practice of law, or to do, or attempt to do, or offer to do any act constituting the practice of law, except and to the extent that the person, firm, or association is licensed or authorized so to do by an appropriate court, agency, or office, or by a statute of the state or of the United States. Nothing in sections 605-14 to 605-17 shall be construed to prohibit the preparation or use by any party to a transaction of any legal or business form or document used in a transaction. Okay. Gotta be licensed or authorized to do so. This is your attorneys, your typical bar members. Those authorized to do so may be, let's see, situations where you have ghostwriting, say, briefs for people. That's been considered to be protected, I believe, under First Amendment. But people are allowed to ghostwrite briefs for other people. They can't go in and actually do the speaking for the person. They can't, they can't go in with all their knowledge and the fact that they're not paid for by the bars, or they don't have a license by the Bar Association, which would be at threat if they were to raise these issues, because these are systemic issues. This would cost them hundreds of millions. No joke, hundreds of millions if they had these issues addressed and if they were to correct them. There were, I'll have to do a video on the Los Angeles Times articles on just, what was this for? Unpaid traffic tickets, I think. And they were auto-issuing warrants for people on over violations at that. There's a case of California v. Staff, STAPF. You're not going to find this online. The case has been buried so hard since about when they started censoring things in 2017 to 18. I have these cases. I'll scan them up at some point. I want to get them out there, but these were big cases, and in the newspapers, Los Angeles Times, they were indicating the hundreds of millions that they would lose simply in unprosecuted violations where people failed to appear. And they were allowing the court clerk to just create a bench warrant in a case. So the court clerk would note, hey, this person didn't appear, okay, and then they would file, a notice and have a bench warrant behind it. So it was all automated. You didn't have judges reviewing it and authorizing a bench warrant. That's where the name bench warrant comes from. The judge, not a clerk of court. So you have a clerk of court doing a judge's job right there without a judge's authorization after reviewing it. You also have the clerk of court doing the prosecutor's job by initiating a charge, the charge being failure to appear. All the court clerk is supposed to be able to do is note that they failed to appear. If they want to try to charge somebody, they then have to notify the prosecutor and provide them with that evidence that they failed to show. And a prosecutor then has to review it and say, well, is this worth our time or not? This guy's got a bunch of traffic, like he parked where he's not supposed to be parked, but we've got these rapists over here we got to deal with, and time-wise, it's not worth our time. Well, these guys aren't doing any of that. They've taken the traffic side of things, and because people are completely, just absolutely ignorant of the process that they're required to do before they even need to enter a plea, they're just taking your money, getting you to go in there. They know the situation as far as what occurred, and people will start pleading why this happened or whatever, and meanwhile they haven't even been charged. There's no charges. But what that does is it allows these people in a bar association to absolutely just plunder millions and hundreds of millions of dollars annually off of the ignorant public. And they get to process the rapists at the same time. But the traffic side things, there's systemic violations of due process. Everybody's having their rights violated there. And whether or not the alleged rapist actually did rape somebody, who knows? They might be getting their rights violated too, because lawyers, you just can't trust these people. There are some decent ones. I'll give you that. There are definitely some decent ones. But they're far outnumbered because greed has gotten a hold of many of them. They see what they can get away with. It's just like the housing bubble, where these mortgage brokers, just the various aspects of real estate have these bubbles that occur, and there's a ton of fraud going on. Same thing with the court system. Okay, so let's see, we've got about 26 minutes in on this. I will have to chop this in two. How much more? All right, let's get to this other section. You guys are going to like that. The footnotes and the annotated codes furthermore cite the following. Non-attorney agents are not allowed to represent corporations in litigation. Is a cop an attorney? No. That makes them a non-attorney. And they're acting, the prosecutors are acting that the cop is acting as an agent here. They're not specifically making these claims. They're in a really circuitous route for logic. They're trying to make it appear as if they are this without being this. They just want to move forward, basically, with the cases against you. So, the state of whatever, they're corporations. Go look them up on Dun & Bradstreet. They're listed on Dun & Bradstreet. If you do a search for, say, the Republic of California, you're not going to find it because it wasn't a corporation. If you do a search for State of California, that's a corporation. It's a subdivision of the federal corporation called the United States. Some of you may be familiar with this stuff. You can look it up. There was an act passed in 1871, and that created the District of Columbia, if I remember correctly. Let's see. Yeah, it created the District of Columbia. Everything federal is within that zone. And in the state of Maryland and Virginia, they actually have these concrete blocks spread out, marking the physical boundary where, they wanted the federal stuff to stay within those boundaries. But, I mean, what are you going to do? Like, the population is just trying to live, just trying to get through day to day, and you have these parasites that understand. Some people will never be able to comprehend the rule sets that the lawyer class has put into place. They're just not, it's like math. They're not capable of going above a certain level. And it's not their fault, but the law is supposed to be carried out in such a way that the average person can understand it. And that's just not the case. So let's see, moving on. Officer Davies is a non-attorney. The state of Hawaii is a corporation. Whoop, there's our problem. These are incompatible things. Civil matter, State v. Bickle, was clearly created when this non-attorney filed the traffic citation infraction with the district court. This clearly violates well-established law. Okay, if you want to look that up, here's the case. Do a Google search on 60, spell this out, 60 Hawaii 372. Try that first. If that doesn't work, then try the abbreviated. And then you can look at the Pacific notations. This covers like Ninth Circuit, I believe. Yeah, it covers Ninth Circuit rulings, Supreme Court rulings get compiled into this. Okay, the citation issued by Officer Davies could not possibly be construed as conveying all of the elements of the offenses alleged, and it would be a violation of due process to allow such a vague instrument to be used for informing a defendant of the allegations for which a defense must be prepared. This isn't strictly adhering to the point that's being appealed, which is the statute of limitations. Right here, we're actually hitting on like a failure to charge at the same time. And I would have put it in its own separate section, but, like one paragraph, I could knock that out, and then it could be said in the appeal that, yes, I did raise this issue, even if the formatting wasn't, lovely. Okay, if upon review of the officer's citation, the county prosecutors determined any offenses took place, it was their duty to prosecute by commencing a civil action against me. The record on appeal shows that no written verified complaint was ever filed by a prosecutor against me. It wasn't until March 1st, 2019 that Prosecutor Linnea Downs entered an oral recitation of essential elements of the offenses alleged against me. You could see where she enters this oral recitation on the transcript of the proceedings, where it occurred March 1st, and right here through these pages is the transcription of this oral recitation. I don't know, maybe I'll try to get this up at some point. I don't know that I want to read through all that. It's like 3+ hours. We'll see, guys. I don't know. If you all can help pull in some more people viewing this stuff, it helps motivate me to do more. So maybe I'll get that up for you guys. All 4 of the alleged civil violations were far beyond the statute of limitations set for the class of offenses in which they belong. Class of offenses. Okay, that's civil violations. Start learning to speak in these terms. These are sets of things. A class. It's like an enumeration. Let's say you want to discuss the like numbers. If you only want to deal with single-digit numbers, you could say the class of single-digit numbers, and most people will grasp that's going to be 0 through 9. And double-digit would be 10 through 99. And class of double-digit numbers would be 10 through 99. So when you're dealing with these classes, you're speaking only of a thing within that, and anything that's not within that is outside of that. So similar thing is the issue of the exemption from a driver's license for those that are not engaged in commerce upon the highways. If you look through my other videos of scanned copies of clerk certified copies of legislative acts, especially the You're Not a Motor Vehicle series, you'll see in there, and they'll lay out the classes. They explicitly describe these classes, those that make money off the highway in the business of transportation versus those that don't. So you got the class that use the roads as a matter of right versus those that use it for commerce. And you're going to be dealing with classes a lot, whether or not like a class of violations even apply to what you were doing, sort of thing. Okay, I raised an oral objection to the entry of these late charges at trial and in the written argument for trial, which, as mentioned supra at paragraphs 21 and 22, were not included in this record on appeal by the court clerk, even though they should have been. Okay, I reiterate the points from the written filing below. Okay, we're going to chop that right here because this is lengthy and I want to keep these videos reasonable size for you all. If the information was useful and informative, please consider giving the video a thumbs up. If you're not subscribed, consider subscribing. If you are subscribed, consider hitting the notifications tab so you know when I post new videos. And as always, anybody that you think could benefit from the material or might be able to kind of snap out of it and wake up to reality regarding the court system and corruption, please copy and paste specific videos that you think will help them and send that to them. Otherwise, this material really isn't getting circulated. Alright, until next time.